Rich MacNaughton, Appellant.
Afternoon, Honorable Council members. I represent CCLA, the appellant in this case. We've heard from a lot of people in the community that they're very interested in the Target store being built, and they are very upset that litigation is holding up the Target store. So I'm going to give a brief overview of the reasons and how we can get the Target store built as fast as possible. Back in 2006, Gail Goldberg, when she first came here as planning director, she admonished the city that the process of allowing developers to change the zoning to fit the project was leading to disaster. She says the proper way to do it is to make the project fit the zoning. 4 years later, after U.S. Census came out, CD 13, which was perhaps most notorious for changing the rules or ignoring the rules and pushing through projects, ceased to qualify as a legal council district. Now, I know that some people that suffer from triskaidekaphobia thought it might be a good idea to get rid of a council district number 13, but we had a law from 1925 that requires up to 15 council members. So as a result, CD 13 took large bites out of Koreatown and out of CD 4, and it continues on to this day. Some of the downtown leaders behind Hilda Solis and Mickey Cantor formed the 2020 Commission, and as in their December 2013 report, they decried the crumbling state of the infrastructure and how atrociously the city was being run, and their call to arms was ignored. Just last week, we had the international group INRIX, at least that's how I pronounce it, gave the scorecard for traffic congestion, and the city of Los Angeles has the worst traffic congestion in all of Europe and all of the United States. They also found that we had the slowest growth in gross domestic product, we had the worst growth in population, and we had the highest unemployment in the country. So I think that Director Goldberg, what she had to say about disaster was correct, because the policy of allowing developers to set zoning has become the standard operating procedure in Los Angeles. As we know, we've had the first stab at a community group with the Neighborhood Integrity Coalition. We've had the ballot proposal for November attacking this very thing. They called it spot zoning. That's been put off until March. Now we have this project, which perhaps is the poster child for spot zoning. We now have a developer who wants the city council to change the law so it can build a project that the courts have declared illegal. And we're not talking about some old antiquated law. We're talking about SNAP, which came into being in 2001, and before it was even a decade old, the city council thought that, well, we can just ignore it because that's the way we do business all the time. Well, Judge Fruin didn't agree, and I doubt very much that Judge Fruin is going to agree the next time that you can just change the law as blithely as you ignored it last time. Now, when it comes down to someone appealing this, obviously CCLA can appeal a yes vote, but Target can't really appeal your refusal to change the law in their favor. So if you want to have a Target store built as fast as possible, the thing to do is to stop all this nonsense of changing the sub-area SNAP, vote no on all of this stuff, and leave Target the option that it should have taken in the beginning. Build a store that's by right, and you can do right by your constituents. Thank you very much.